Good evening. Welcome at the Jefferson. Welcome to another great program, the second installment with Pennsylvanians for Modern Courts. My name is Angela Beaumont, and I'm the program director at the Jefferson. Please help yourself to water, tea, and coffee, and we always have snacks out. That's a new thing, like fancy snacks. For the Q&A part, you know the drill. We will pass around a microphone, so please wait your turn. Tomorrow at noon, Deborah Gross here and Phil Friedman will conclude this three-part series with a presentation on alternative ways to pick judges. Also tomorrow at 4, there is a digital program with Dr. Philip Payne and Dr. Andrew Roth and Jefferson's Vice President Ben Svegan. They will be giving a presentation on 1968 and 2022, the seeds of our discontents. This event is live streamed on Facebook and can be is made available as video on demand on our website the day after. On Tuesday next week, July 26th at noon, Mary Beulah and Jennifer Ponzer will present Erie County Career Pathway Alliance, Dynamic Collaboration Shaping Our Future Workforce. In tonight's lecture, Ms. Deborah Gross will discuss the Pennsylvania Constitution, the oldest constitution in the country, how changes to the Constitution occur, and ask whether amendments adopted since Pennsylvania's last constitutional convention in 1967 enhance or threaten our representative democracy. Deborah Gross comes to Pennsylvanians for Modern Courts from over 35 years of private legal practice in federal and state courts all over the country, concentrating on complex commercial litigation. She was Chancellor of the Philadelphia Bar Association in 2017 and focused her efforts during the city's extraordinary legal nonprofit community. She spoke out on behalf of the Philadelphia Bar Association on the importance of judicial independence as the cornerstone of democracy, and both received a proclamation from the mayor as a result of the work they did to train lawyers to assist lawful permanent residents in becoming naturalized citizens. Debbie also served as president of the Philadelphia Bar Foundation in 2013 and 14, and as a trustee of the foundation from 2004 to 2020. And she served on the Bar Foundation's Fundraising, Grants, and Finance Committee. Debbie teaches at Villanova University School of Law and received her JD from Boston University School of Law and her Bachelor of Science in Economics from the Wharton School of the University of the Wharton School of there's a mistake here. The Wharton School of Pennsylvania, is that correct? Of the University of Pennsylvania. So, I was seeing it right, but it didn't make sense for a moment here. Wharton School of the University of Pennsylvania. I'd like to thank you, Ms. Gross, our scholars and residents, our board, our staff, our members, and of course you, our dear audience today. If you're interested in becoming a member, please talk to our staff or take a brochure. I'd like to also mention here, if you're interested in volunteering at the Jefferson, please also talk to me, talk to Raven Clark. As we go into the fall with the Global Summit, we are always appreciative of volunteering and volunteers supporting us during those events. So without further ado, I'd like you to welcome our speaker tonight, Ms. Gross. Thank you so much. You can just like as close as you can.
Yep. Okay. Good evening. Thank you, Angela. Thank you for having me. Okay. It's me alone tonight. For those of you who came last night, I actually changed up the presentation just a little bit since I touched briefly last night, but for those of you who weren't here last night, don't worry. We're still good. And it's interesting, I'm speaking on constitutional amendments, and I thought I knew a good amount about constitutional amendments, and then I started researching. And there are scholars out there, and I quote some of them, who have written on state constitutions and the various methods of amending constitutions, the reason the constitutions came about, and I found myself really enjoying it. So I encourage you to do research because it was truly something special that I enjoyed, and it was out of the, not in my everyday reading. So constitutions. We all hear about the U.S. Constitution. I've gone into high schools and I've talked about the U.S. Constitution, and then I ask students, do you know that Pennsylvania has a state constitution? Do you know that every state in our country has a constitution? And it's a piece of information that they don't always learn about. So, why is it not going forward? From beginning? Do I have to, maybe I didn't hit from beginning. Let's try it. No. Aha. Okay.
It's not. Okay, that'll be quickly fixed. Put it again.
Shut your phone off and start it back again, and it works.
Yep.
Okay.
There you go.
Great. Okay. Okay. So, what's a constitution, right? It's a document, but it's more than just words on a page, right? It is a document by which a society or a government reflects society's values and offers a framework for protection and institutionalizing those values. Why do we need a constitution? People have different opinions, but it's to protect rights, to understand maybe the limits of government, to protect freedom of speech, not necessarily policy issues, but more individual rights. I'm going to talk a little bit about the U.S. Constitution versus the Pennsylvania Constitution, and I was thinking I could afterwards make this into a PDF and make it available because I actually cite a lot of websites on here so that you can browse them at your pleasure. But this is I went to the websites for the U.S. Constitution versus the Pennsylvania Constitution because I want to talk a little bit about the difference. So the Pennsylvania Constitution was actually created before the U.S. Constitution was ratified. We in Pennsylvania claim we have the oldest constitution in the country. Massachusetts does take issue with that, so I am giving you full disclosure. Ben Franklin co-authored our Constitution as well as helped write the U.S. Constitution. We'll talk about amendments, but our Constitution has been amended 5 times before 1968, before another version of the Constitution was approved. Both constitutions create 3 branches of government. And we've talked about that, but 3 branches of government to me are like a 3-legged stool, and you need that balance. One may be a little stronger than another at different times in our society. It may wobble a little, but we need those 3 legs. So what other differences are there, right? The U.S. Constitution has 7,000 words. It is up for more interpretation, I will say, right? It's judicial interpretation. We all know where that goes. I'll be neutral. Pennsylvania Constitution has 37,000 words. It's actually not that wordy a constitution, although it does provide more rights than the U.S. Constitution. Alabama is the state with the largest constitution and largest number of words in its constitution, 388,000. The Alabama Constitution was attempted to be amended and made into a shorter version, and the Alabama Supreme Court ruled that the process by which that was undertaken was unconstitutional. Okay, I'll let it be at that. The U.S. Constitution, it protects fewer substantive rights. It's more remote. It's more bigger concepts, not, right to bear arms. It's not the same as our Pennsylvania Constitution. We have a wider range of subject matter. It's closer to the people. It reflects the people's values and society preferences. Interpretation. Because the U.S. Constitution is really only 7,000 words, and as we'll hear later, is much more difficult to amend, interpretation is up to judicial interpretation. By contrast, the Pennsylvania Constitution, as we'll learn, is a little easier to amend, so therefore it's not only judicial interpretation, but it's, I'll say, popular interpretation. So if we don't like something in the Constitution, the court may rule in a matter that something was unconstitutional, we can actually change the Constitution and overrule a court decision. And again, there's a difference in the processes to amend, which we'll explain later. But the U.S. is clearly the most difficult process, or the most difficult constitution, has the most difficult process of amending a constitution. So how do we amend constitutions? In Article 5 of the U.S. Constitution, it sets forth the ways that we can amend our U.S. Constitution. Congress can propose an amendment. It has to be approved by 2/3 of both houses. Then the National Archivist, I honestly don't know who that is today, sends a notice to the governors of states that their states have to ratify the constitutional amendment. A state's ratification, it's a yes or no vote. It has to be the exact same wording. There cannot be any changes, and there has to be 3/4 of the states have to ratify the language. The governor's approval is not necessary. So ratification is done by the state houses and the state legislatures. Okay. There's another way, which has not ever been used, but it's provided in Article 5, and it's that the state legislatures themselves could call for an amendment of the Constitution. Now, 2/3 of the legislatures must call for amendment. Can you imagine 2/3 of the legislature sitting down in a room and agreeing on anything? And then Congress has to call for a constitutional convention, which can propose the amendments, whether or not Congress approves it, and then the amendments are sent back to the state for ratification. So it's a much more complicated procedure, and it has never been used. Congress can choose how the states ratify the proposed amendments by the legislature, or Congress could require, by the legislature is the most common form, and it's the only form that's ever been used, but it could require the state calling for a constitutional convention simply to approve the amendment. That, again, hasn't happened because, I can't even tell you why, but it just hasn't happened. It's probably too cumbersome. So, over time, the majority, I'll say, of the amendments occurred in the Bill of Rights, right? The first 12 amendments were added by 1804. We all know how important they are. The 13th, 14th, 15th amendments were added in 1865 to 1870. 1913 to 1920, there were 4 more amendments. 1920 to 1971, there were 7 more. And then, I say there were no others, but there was one unusual situation. So you can see we really haven't had any constitutional amendments since 1971. So the unusual amendment, it's the 27th Amendment. It was proposed with the original Bill of Rights. It was only ratified by 6 states, and then it was ignored. It had to do with increases and decreases in salary of Congress. The Article 5 doesn't say the time period that can lapse, I'll say, between when the first state ratifies and the last state ratifies. So in 1992, 200 years after the amendment was first proposed, there was a ratification that reached the 3/4 line of approval, and it became the 27th Amendment. Now Congress has written into, when they're proposed, usually, I'll say usually because we don't see that many, but has written into some of the most recent proposed amendments a time limitation as to how long it could take before there are, ratification by the necessary number of states. So the one most recent constitutional amendment that you may have heard about, and even more recently it's been in the news, has to do with the Equal Rights Amendment. So it was originally, approved by the House of Representatives in 1971, approved by the Senate in 1972. It had 35 states' ratification through 1977, and then sort of sat there for a little while. So then the question was, okay, since it's been sitting there languishing, can the states revoke their ratification, or does it sunset? There's not been any decision on this matter because they still haven't reached the requisite 3/4 number of states, and there wasn't any specific time limitation in the ERA amendment. So I know, for example, Pennsylvania has not yet ratified the ERA amendment, or the Equal Rights Amendment. The Pennsylvania Bar Association, the Allegheny County Bar Association, the Philadelphia Bar Association recently re-upped a resolution that the state should ratify the Equal Rights Amendment. It hasn't really gotten anywhere, but they're trying to keep it alive, and other states are as well. It will be an interesting question, which I guess, if we got to the requisite number of states, could go before our Supreme Court. So we'll see. But it's not there yet. And then this is just a little bit of the status of the Equal Rights Amendment. So, so what the key takeaway here is that the United States Constitution is really difficult to amend. So in over 200 years, there have been 33 proposals submitted for ratification of the states, which is not a large number. Only 27 of them have been approved. So, the founders of our Constitution clearly intended it to be a document that isn't too fluid, but is more subject to judicial interpretation. Only 8 in the past 100 years. Over 11,000 have been proposed, but only 33 actually made it to the states for ratification. Okay? So a little bit of history about state constitutional amendments. So before 1800, only 3 of 26 state constitutions authorized legislatures to amend the Constitution. So the main way states before 1800 could amend their constitution was through constitutional conventions. We had one in Pennsylvania in 1967. That's the last constitutional convention we had. I can't tell you when some other states have, but it is not something that you hear about too frequently. And the reason that they had constitutional conventions was that it was to hear what the people had to say. But it was also determined in the 1800s, I'll say, that it was a little cumbersome, that it was difficult in the 1800s, it's probably not as difficult today, quite honestly, to communicate that we're having a constitutional convention, you need to come and vote, you need to come and understand, debate, and have a vote. So it's the advent of internet, it's probably not as difficult. So since between and then the constitutions don't typically get changed, right? The constitutional conventions had some constitutional conventions were only for changing a specific amendment. Other constitutional conventions actually addressed changing the entire Constitution. So the concern is also with the Constitutional Convention that it could sort of get out of control. I was talking to an attorney, I'm trying to think where he's from. I don't think it's from Erie, but who called me because he attended the 1967 convention. And at the 1967 convention, Pennsylvania Constitutional Convention, the article about the judiciary was discussed, and how you elect or select judges in Pennsylvania was discussed. And the topic of choosing, instead of electing judges, but actually selecting judges by appointment was up for debate in 1967. And this attorney said to me how they had to have a cutoff time for the end of the convention. But had they gone another day, he's convinced that we would not be having elections in Pennsylvania, but we would be having a judicial merit selection, I'll say, of judges. But he's like, I can't believe they couldn't go one more day. But I said to him, this is what happens. So since 1964 and 1975, there were 9 states that have drafted new constitutions. And then since 75, there's only been 2 states that have completely revised their constitutions. One was Georgia, and the other is Rhode Island. Recently, probably within the past 20 years, I will say the Alabama Constitution, as I mentioned, there was an attempt to revise it or amend it or draft a new one, but it failed. So the Pennsylvania Constitution, there are 5 versions of the Constitution. So from 1776, 1790, 1838, 1874, and 1968. So the 68 Constitution was what came out of the 67 Convention. The 1776 and 1790 Constitution had no right to have amendments to the Constitution. You had to have a constitutional convention. So where in our state's constitution, Pennsylvania's constitution, can you find the rules for amending the Constitution? So I rushed through this yesterday, so I'm going to go a little slower today. But it has to be a proposal by the House or the Senate. It then has to be approved by both the House and the Senate with the exact same language. That's the first pass, we call it. After the first pass, it has to be published by the Secretary of the Commonwealth in newspapers, right? 3 months before a general election. And I challenge it, like, the newspapers are going out of business. Why have we not brought this process more current? And why isn't it okay to publish it on the internet? I mean, I actually, when we were researching for the constitutional amendment that was proposed with respect to districting the appellate court judges, I wanted to go back and see the advertisement that was in the newspapers and where it was placed. They didn't place it in the Philadelphia Inquirer or the the Pittsburgh Tribune. They placed it in small newspapers. It was hard to find, intentionally. So, that's in my head, like, how is that process? How is that due process? How can that be allowed? And it seems like a simple enough requirement. Publish it in some newspapers, at least 2 newspapers in every county, across the state. Unfortunately, in 2020, I don't know if those of you recall, but there was an innocent mistake made by the Pennsylvania State Department, and and it didn't get published. I can't tell you it's innocent or not. I know you're making a face. I have no idea, but I do know Kathy Bachvar, and who was terminated in her position as Secretary of State because of the gravity of this mistake. And she said there was a communications issue between her office and others who were supposed to set it up. So after it has one pass from the House and Senate, publication, it then has to again in the next consecutive session. So remember, our House legislators are elected every 2 years, so it would be in the next consecutive session. It could, depending on when it's passed, but new session. Again, has to be approved by the House and Senate with the exact same language. It has to be again published, and then it goes as a referendum to the electors. It does not say, and I'm giving this as food for fodder, I guess, does not say which ballot the referendum has to be placed on. Does it have to be placed on the primary ballot? Primaries, typically only people who have registered for the Democrat or Republican Party go to primaries. So if you're an independent, you may not necessarily learn about the referendum on the ballot. Is it on the general election ballot? Is it on the general or primary election ballots in an off year, which I hate using that term, which means an odd year and is typically a judicial election year. Also, leave that as it may. Okay, so, again, there's a lot that's not included in in the Pennsylvania Constitution about this amendment process, right? There's no requirement for public debate. There's no requirement for a public education campaign. Again, as I said before, there's no requirement that it be on the general ballot in a busy election year. And then there's this question about the wording, right? The wording, I always say, who drafts the wording of the ballot questions? Like, how do they come up with them? There have to be a limited number of words. They have to be plain language. But what is plain language, right? So, as a lawyer, I used to practice class action law, and I did plaintiff's class action work, and I'm sure many of you have received these notices in the mail. Years ago, they used to be like 30 pages. Now they're shorter postcards that you go online and find out. But the requirement within the past 10 years, I guess that's recent, was that it had to be plain language because people were getting these notices and it was filled with legalese. So as I said something yesterday, the wording on the ballot is misleading. There was a ballot question about whether you would approve the retirement age of judges at 75. What they didn't disclose is that we had already had in Pennsylvania a retirement age of 70. Does anybody know why that was moved to 75? Say it again? Exactly. Who did it benefit? And I don't want to take anything away from his being a capable jurist, but there was a judge on the bench named Justice Saylor who just retired last year, who was close to turning 70. And he is a Republican, and they wanted to extend his stay, and his brother was in the legislature, and so they proposed the age limit to 75. This amendment had been proposed earlier, I think even when Justice Castile was Chief Justice, and it didn't make it as a proposed amendment. So the other Pennsylvania, process for constitutional amendments is that no amendment or amendment shall be submitted more than once in 5 years. So they can't keep trying. If they haven't, so for this judicial redistricting amendment, if it is not passed by the legislature in this term, meaning before January, when the new legislators come in, it's dead for 5 years. Can't say it can't come up again, but at least there's a 5-year reprieve. When there are 2 or more amendments, they need to be voted on separately. So a proposed bill, and actually recently, Senate Bill, I think it's 106, which we'll discuss a little bit, could propose 5, this is what the one just happened overnight within the month of July, did propose 5 constitutional amendments, passed altogether by the House and the Senate. However, when it becomes a referendum and when it goes to the people, they have to be voted on separately. And again, they have to be single subject rule. So they cannot amend more than one subject of the Constitution. So there has been litigation over whether a proposed constitutional amendment amended more than one topic in the Constitution, and I forgot to cite that case, but it was in the past year, and that proposed constitutional amendment, which we actually voted on, and then the ACLU brought a lawsuit about the single subject rule, and everybody voted on it at the ballot box. I think they even counted the vote, and it was enough to approve it, because it's just a majority, but the Supreme Court ruled that the wording of the proposed constitutional amendment was what violated that single subject rule. So our current Pennsylvania Constitution has been amended 49 times. The most recent amendments occurred in 2021. Does anyone remember any of those constitutional amendments? One had to do with we spoke last night, one had to do with the authority, the executive authority, that it took away the emergency power of our governor. But there were 5 questions, and it seemed like it was confusing. And how did you know what to vote for any of them? There was no information about them that was even submitted by any of the nonprofits, I will say. Okay, it's not too bad. So these are the 5 amendments. One had to do with the termination or extension of disaster emergency declaration. There was a total of 1.9 million votes on this because 2021 was a odd-numbered election year. We had only 2 million voters go to the ballots, and this was in the primaries. So the vote was a 54% to 46% vote, but it was a majority vote. The second question had to do with the disaster emergency declaration and management. Again, the numbers passed were 54 to 46%. Then there was a proposed constitutional amendment about the prohibition against denial or abridgment of equality of rights because of race or ethnicity. People understood that. That was a 71% versus 28% vote, 29%, right? And then you had I can't even remember what this was, but it was another question, and again, it was a pretty large 72% versus 27%. So questions 1 and 2, right, passed by only 54% of the vote. So therefore, we are having a minority percent of our population in Pennsylvania making a substantive, serious decision about amending our Constitution for all of us. It's a little concerning. Right. So last night somebody asked, did voters reject a ballot measure? I would love to tell you yes, but there were 2 instances in the past 100 years where voters have rejected a ballot referendum. The research shows that people don't understand them. People trust that they've been vetted and discussed, and they go in there and they just think, okay, that makes sense to somebody else, so I'll vote in favor of it. So in 1993 and 1989, those were the 2 instances of of Pennsylvania rejecting a proposed constitutional amendment on the ballot. So with this House Bill 38, and I'm sorry I keep coming back to it, but this judicial redistricting bill, it was the first, I'll say, organized effort. There was a coalition across the state of legal nonprofits, of good government groups, of judicial independence groups joining together to go against this judicial districting bill. So, how we in Pennsylvania, in other words, amend our Constitution is, in essence, from our legislature. Is that good or bad? I'm not going to voice an opinion. I want to hear your opinion later. I'm going to give you information, and you can tell me what you think. But most of our proposed constitutional amendments don't have to do with our legislature. Our 3 branches of government, yet they typically are proposed constitutional amendments affecting our executive and our judiciary, but not the legislature. I guess they don't want to legislate themselves out of business, right? Is this a way for the legislature to run around a gubernatorial veto? So we have in Pennsylvania, the House and the Senate are Republican, the governor is Democrat, and so that they know that there are certain issues or topics that the governor will veto. They've been told ahead of time, they know it. So what do? They decide it's important. It may just be something that could have been a statute. It could have been a law. But instead, they've decided they're going to make it a constitutional amendment because they think, okay, we'll take it to, it'll be easier to get it passed by 2 consecutive sessions. Governor has nothing to do with the proposed constitutional amendment. Excuse me. And the voters, they vote yes. So let's take it to the voters. So, does a decision by 11.11%, is that considered a decision by the people? I mean, that was the purpose of making the constitutional amendment process easier. It was to make sure it reflected the will of the people. Is this doing it? Also, there's an article that I'm going to cite throughout, and the author is Jonathan Marshfield, who wrote in 2016 in the Arkansas Law Review. But he talks about how this legislative referral method, right? The legislature's referring it to the referendum, is vulnerable to capture by special interests. Well, as we know, special interests now have a lot of lobbying. Do a lot of lobbying on, of our legislators. They have a lot of financial backing, and many of them actually draft the proposed amendments and bring it to the legislature. So this, because of the, I'm going to use the term, but because of the undue influence of special interests on our legislators, therefore it translates to undue influence on this legislative process. So, does our process that exists currently undermine and threaten our Constitution? Again, the General Assembly has been considering changes in the shift of power to the legislative branch. We discussed there's a proposed amendment out there for the legislature to literally take over the rule-making authority of the judiciary, to take over the oversight of the courts from the judiciary, to take over the oversight of the practice of law that the judiciary does, and it all should go back to the legislature. There's currently constitutional amendments to change the process of electing our appellate court judges. The one bill that is the most threatening has to do with the districting of our appellate courts. And for those of you who were not here yesterday, and I'll explain it, and those of you who were, I apologize for repeating myself. But the proposed constitutional amendment proposes 7 different geographic districts to elect the Supreme Court, proposes 15 different geographic districts to elect the Superior Court, proposes 9 different geographical districts to elect our Commonwealth Court. And this bill doesn't explain the process about how that will come to pass. Are we getting rid of 15, 9, and 7 judges in one fell swoop and starting from scratch? Are we getting rid of and I hate to use that term, getting rid, but are we, when a judge is up for retention election, is that judge not allowed to run for retention election because there's another judge that's sitting from that same county? There's just no explanation of the process of implementation. But can you imagine an immediate change in, 7 Supreme Court justices, 15 Superior Court judges, and 9 Commonwealth Court judges? What a body of law and of history we could lose in one fell swoop. There's also, a proposal to change the districting for voters. So there's a lot of different proposals out there that hopefully will not get too far, but they do exist and you need to know it. Spotlight PA created a tracker this year for the constitutional amendments because there were so many this year. We have a lot of proposed constitutional amendments. I will not deny that. But in this legislative session, we have had more than is typically common, and that has to do with the fact that there's this division between the executive branch and the legislative branch. So, should we amend the amendment process? And again, it would be a constitutional amendment. So, constitutional amendments aren't necessarily bad, but they are clearly confusing. So, should we require supermajority approval in the General Assembly, right? Right now, it's only majority. It's 51%. Should it be a little more difficult? Should we require public debate and opportunity to make more informed and more deliberative decisions? Should we require that any kind of referendum be placed on a major election ballot? And again, should there be a public education campaign? And all these could be written into a constitutional amendment to amend our constitutional amendment process. Didn't get that confused. Okay, so what do other states do? So there is a wide range. 49 states currently permit amendments by legislative approval, followed by a public referendum for ratification. Majority of those states require, 2 legislative sessions in the same same as Pennsylvania. I have not done the research, I will tell you, to see whether there's a requirement as to whether they be in general elections that are busier elections, but they do have, public referendum for requirement. 18 states permit amendments by a constitutional initiative, meaning the people can actually suggest that there be a referendum. So we hear a lot about California and how they do a lot of have a lot of constitutional referendums. Is that a good thing or a bad thing? So the referendum, the initiative by the people does not necessarily, not all states are the same, require legislative participation, although some states limit what types of initiatives can be placed on the referendum. Delaware is completely unique. It does not allow for any amendment by public initiative. So it doesn't ever go to the public. It only requires that the legislature ratify or approve it, 2/3 vote of each house, the Senate and House, and in the second consecutive session. But it never goes for public approval, which I find amazing. Then there are 3 states that allow for amendments to be made by calling a limited constitutional convention. And then Florida has a unique process. In its constitution, it actually requires for the creation of a Constitution Revision Commission every 20 years. And that commission reviews the Constitution, decides if there are any proposed amendments, and then submits it to the voters. There's pros and cons of that way, but there is a lot of public, I will say, education and debate. So the citizen initiative method, where similar to California, I will say, it sounded great in the beginning. It was working wonderfully. There is now a lot of criticism about it. So one of the concerns or criticisms is that, it circumvents deliberation and the lawmaking expertise. So here, the commentary says that lawmakers have expertise about amending constitutions. Now we're just letting citizens amend our Constitution, and we're not having that public debate. But that's assuming there is public debate. In Pennsylvania, we have constitutional amendments that are made by our legislators, and I can assure you, I've watched them on the Zoom, and there's no public debate. They're not even allowing the opposing party to even speak. That's one criticism. I can't tell you I believe that has any validity, but then maybe I'm not giving my government legislators enough credit. The belief is that representatives are accountable. So therefore, citizens aren't necessarily accountable to one another, right? If citizens approve a citizen's initiative, one neighbor doesn't say to the next neighbor, did you vote? We lost because of you. But a legislator could be voted out of office if he or she approved a proposed constitutional amendment that wasn't popular with his or her district. There's also a concern that in a citizens' initiative, citizens aren't going to debate. They're not going to have this public debate. They're not going to have an education campaign. It's interesting because there's a lot of law journal articles out there about these issues, but you don't have the experience. Like, there's not a lot of fact to support arguments because the state constitutional amendments processes have not really been used enough to study them. But the only thing I will say is that the citizens' initiative has become a big business, and they have found that out from California. There are companies now, so to put an initiative on the ballot, you have to have so many votes, right? So before it gets voted on, it has to have so many votes. So in California, there are companies that now, go out there and pay people to get votes, so to put an initiative on the ballot. And the funding of these companies that, to get the signatures is from large corporations, is from special interest groups, so that it has been, it's no longer the purpose for which it is served. So is a citizens' initiative a good method anymore? So I did a review of the various constitutions across the country when they were last amended or existed, and how many amendments. We talked about Alabama as being the wordiest constitution. It actually adopts constitutional amendments, almost twice a year. So it's also probably the most frequently revised. I cannot tell you what's peculiar to Alabama that it has this frequency, but it is. By contrast, Connecticut has only had 32 constitutional amendments adopted, or Alaska has had 28. I mentioned that Delaware, again, doesn't require voter approval. What other interesting things? Indiana really, it replaced its constitution, and we couldn't even find that many. We couldn't find any constitutional amendments. We don't understand why, but that's what we couldn't find. Louisiana adopts amendments more than twice yearly. Mississippi has a citizens' initiative, and a lot of states have citizens' initiatives and legislative referendums. So Oklahoma has had more than 150 amendments. Oregon, 254. It has actually had a constitutional convention, I think, in the 1900s. And so the finding is that states amend their constitutions relatively frequently compared to our U.S. on a variety of issues, that the state amendment process, 99.5% of the amendments in the last decade occurred through mainly legislative referral or the citizen initiative. And this man, Jonathan Marshfield, who is not in support of the citizen initiative, thought that process, if we were going to stick with it, should be changed to include our county legislative bodies, that people have become more involved in their county government, and so therefore that would be able to encourage more public discourse and debate, which is true. We have learned that our school boards, our local county boards, there is much more, more people want to run. There's much more information now out there. Plus, our local counties are more involved in our state government, in our federal government, and helping people with disasters, that people now don't hesitate. They have more trust in their county governments. So the thought was, or his suggestion is to continue with the citizens' initiative, but have it sort of come up through the county instead of through a professional, through professional organizations. So I did a little question and answer, right? But it's put the answers, so I'm cheating. But, you know, again, how many words are in the original Constitution? It's 4,543. You know, how many amendments to the U.S. Constitution have been repealed? Only one. It was the 18th Amendment for Prohibition. You know, which state has the shortest Constitution? It's Vermont. Which state has the longest Constitution? That's, you know, Alabama, and it has 892 amendments. It's crazy. This document, I wanted to show you this, said that Massachusetts has the oldest Constitution, but if you talk to our Supreme Court justices, who just celebrated the 300th anniversary of our Supreme Court, they will tell you that it's Pennsylvania who has the oldest Constitution. The newest constitutions are Georgia and Rhode Island. The Constitution that has been amended the least is Illinois, and the state that has adopted the most constitutions is Louisiana. So I have finished my constitutional presentation, amendment presentation, and I would love to take questions. It was truly an interesting experience learning about all this.
Please wait for the microphone.
No worries.
I know, we're so tough here.
I'd like to know more about the Spotlight PA. Can you give me some of the background on that?
Sure. So Spotlight PA is a news organization that's funded by a number of nonprofits. I know one of the funders is the Lenfest Foundation, and they actually keep a running tally. Whenever there is a proposed constitutional amendment in the Pennsylvania House or Senate, it's added to this list. So if you go on this website, you'll see over 70 different proposed constitutional amendments that have occurred during this past legislative session. So and there was no central repository of this information. Like you could go onto the pahouse.gov, the Senate site, and search for constitutional amendments, and you couldn't find that information. And that's also part of this educational process that's missing, right? It's sort of, I always say that they're trying to put these proposed constitutional amendments, through the evening, through the night. Like the one that Senate Bill 106, I think it's 106. That's what I said. It was after they had approved the budget in July. It was past midnight. They approved, the House and Senate approved 5 proposed constitutional amendments, one of which dealt with abortion. I mean, if you listen to some of the testimony or argument, I'll say, on the Senate floor, and the House floor, it was unbelievable how, some people had left the floor, didn't even know that these proposed constitutional amendments were going to be brought to the floor for a vote. But it clearly had been, planned, but just not even disclosed to the legislators of the opposing party.
Any other questions here? Oh, okay.
You said that Mr. Marshfield believes in having the county governments be more involved.
Yeah.
I'm just not sure how that helps the populace, though, because the people don't tend to vote in local elections at all.
Well, but more people is what his belief is, or that more people are relying on their county governments for more services, that their county governments now have become much more communicative with their constituents. So the thought is that it's a closer relationship between their county governments and the constituents than the federal government. We have 2 senators in our state, right? 2 federal senators in our state, and how can they get around and talk to everybody? Whereas a county commissioner has a more finite geographic area.
So it's better representation. Thank you.
How many states do like Pennsylvania and elect judges? We're from Rhode Island, and when we moved here, it was like, you what?
Yeah. So Pennsylvania is one of 8 states that elect Supreme Court judges, right? A majority of states do elect their trial court judges. But Pennsylvania is one of 8 states that elects their appellate court judges. What are the others? I do not have that information in the top of my head, but I will have that tomorrow. In Rhode Island. I mean, but it's not always, right? This is a preview, but how judges are picked varies by state. Some are picked by governors. Some are picked by a commission made up of politicians. Some are picked by a commission made up of judges. So it's a wide variety, but there is definitely some question about electing judges. I mean, I can tell you, I'm disclosing too much, but I know in Philadelphia we had a trial. I remember, so I was chancellor of the Philadelphia Bar Association. The Philadelphia Bar Association has a judicial evaluation committee similar to what the Allegheny County Bar Association has, similar to what the Pennsylvania Bar Association has. But we focus in Philadelphia on judges people who are running for elected offices in Philadelphia or whose offices are in Philadelphia. So there was an individual who ran for a judge in Philadelphia who was not qualified. The Philly Bar Association ruled him not qualified. I mean, he came in front of us, and it was embarrassing is the only way to say it. But he got the #1 ballot position that year, and there were 40 candidates on the ballot. So how does somebody pick a candidate when they don't even know anything about them? And so usually you check off 1 to 10. I mean, and it depends, right? Is it the 1 to 10 going down? Is it 1 to 10 going across? And do you know how you pick your position in Pennsylvania, your ballot position? Does anybody have any idea? Out of a hat. It's paper out of a hat. We do have a sophisticated enough system right now that actually the placement of names could change for every voter so that there wouldn't be that same, but it's not used. Anyone else?
I apologize in advance. This question is a bit long-winded, but turning to the federal context, it seems that eras of political polarization would almost render the constitutional amendment process impossible, kind of like we have now. So do you agree with that assessment? And if so, what do you think it means for the future of the process?
So I agree with you. I mean, because of the requirement, right, of 2/3 majority of the 3/4 ratification, I think an amendment of our U.S. Constitution is quite an uphill battle. But I don't necessarily think that's bad. I think that gives us the stability, right, of 200 years of democracy. Now, the question, as we all know, is how that Constitution is interpreted, and we have all these various, originalists and theories, but I don't think there's, for our U.S. Constitution, we were founded on on the reason that the states should have more power. There should be more emphasis in state government control than federal government control. So I think that it's good that the federal Constitution is stable, and that the state constitutions could be more flexible in understanding how we run our everyday lives. Yes, there are clearly issues right now about judicial interpretation, but you're not going to like me for what I say, but pre-Roe, people felt that there were issues for judicial interpretation once Roe got passed. So, we ebb and flow. We used to have, our Supreme Court over time has typically been pretty conservative. We've all been living in I'll say the past 50 years of a much more liberal Supreme Court. But for the majority of the Supreme Court's existence, it has not been liberal. We're sort of just used to that. And I'm just stating sort of a fact. I'm not taking a position on this, but I've been listening about, I've been, upset about what's going on. It really is impacting, in my mind, people's confidence in our judiciary and our democracy. But I've been listening to even liberal podcasts who talk about how we forget what it used to be. So it's a long-winded answer, but I think it's a good thing.
Thank you.
Any other questions? Wasn't as exciting a topic as yesterday, I'm sorry. But it's something that we all need to learn about because we really don't know. And it is scary that these ballot referendums have becoming more frequent and less public. There's a interesting correlation with the increase in how often they're on our ballot and yet the lack of information.
I would like to, just one last question here from me. How can we educate to me, the best education I was enjoying was the mail-in voting when I had time to look up what's behind that question on the ballot that before, when I went into in person, was like impatient, had no time, just checked it off and didn't care. But then the next time I was like, I gotta look this up. And then suddenly I understood. So
the only good thing, there's two good things, right? They do publish the ballot ahead of time, not only in the newspaper, but I know the League of Women Voters publishes it as well. Also, we can now bring our phones into the ballot, whatever ballot area. And so we can, ballot booth, thank you. So we can, do our homework. You take your time. There is no need to rush. Make sure you do your research. Yeah, it would be much better if it could be, you could prepare, but I can't tell you how many calls I get from friends who are, I'm voting, what should I do?
I've always done that. Yeah. I would just like to suggest, because it seems to me that that what tends to be happening right now is that one party, it may be fine if you're a member of that party, but if you're not a member of that party, it's not so fine, that one party has grabbed that amendment process and has hijacked government altogether. That's my personal interpretation. But I would say that maybe a good thing for everybody to do when they're thinking about these amendments is to look and find out when they're doing their research, how many people, was this a totally one-sided thing by the legislature? Was it all Republicans or all Democrats that voted one way or the other? Because if you don't have bipartisan support, maybe that's a good one for you to say, no, we don't want to do this.
So it's interesting. It's easier, right, if you know the bill number. You can plug it into the internet. You can get the legislative voting history. I'm trying to think of the ballot, and I don't think on the ballot, I'm pretty sure the ballot does not put the bill number. But, if you could figure that out, you'd be able to find that information out in a heartbeat. Angela, behind you.
Thank you. I think there's an easier way for this. In our state, House and Senate, the procedural rules that are passed at the beginning of each two-year session give total control to the majority party.
Yep.
There are two leaders within that majority party that actually appoint the chairs of each committee.
Yep.
Each of those committees has 15 members from one party and 10 from another party.
Yep.
Every one of those legislators' offices, both at home and in Harrisburg, are funded by those two leaders on both sides. So the thing is, it's real simple. The corruption within the Republican Party, I'm just going to say it, nobody can, I would love for somebody to actually show me evidence I'm wrong. But I have looked at these amendments, I have been paying attention to all of them, and the corruption is so deep. They are trying to take away not only our mail-in ballots, but our drop-off boxes. They're actually trying, they have an amendment that would allow, and it's called the Citizens Reapportionment Commission, and that would allow 6 legislators, and 5 of them would already be, according to the amendment, would already be members of the majority party, to redraw the maps. They also will take over the college that appoints our president, that votes for our president.
Right, the Electoral College.
Yes. So they will have control of that as well. So the corruption is here. I just encourage everyone, go to the polls. Don't vote anymore on the person. Vote on the party, and then once that other party gets in, say, you see what we just did?
So the only thing I will say is that while I understand where you're coming from, I do know that there was a lot of pressure on conservative legislators who are reasonable, okay, is the only thing I can tell you. And I know because I spoke to a number of them, during this House Bill 38 situation. And the ones I spoke to, were lawyers. And I can tell you Paul Schemmel, who's in Waynesboro, Pennsylvania, which is south, and he is a very strong R. But he was against this House Bill 38. Natalie Mihalik, who is an R from Allegheny County, was against House Bill 38. Todd Stevens, an R from Montgomery County, was against House Bill 38. So that they have to be, when they're, I hate to say this, it's herd mentality, right? When they're together, they have to support each other. But if you can start, there are reasonable legislators out there. And also, for that bill, it's easier to approve a constitutional amendment the first time. There's no pressure. You can say, I can vote in favor of this. I know I'm personally against it, but I can vote in favor of this because I'll have a second opportunity to vote no. And this way I'm appeasing my other, Republicans, okay? But when push comes to shove, I'm not going to support it. And I know that's the story with House Bill 38 as of right now, because I've spoken to them. So, yes, there were 5 horrific bills that are proposed constitutional amendments that came out on the eve after the budget, and those were the 5. I personally do not believe that if they were proposed again, that you would have that same voting pattern. But that's my own personal opinion. Right. Yeah. Or not. Right. Yeah. There's actually a representative named Timothy Briggs who has who has a proposed bill to amend the constitutional amendment process, but he can't even get it to the floor because there's a process by which a bill has to come to the floor, and if you're in minority, you're not getting a bill to the floor unless you have co-sponsorship and approval from both leaders. But he has a bill. And so, you know, honestly, the hope is like every time there's a proposed constitutional amendment, he gives the same lecture. He says, you know, this constitutional amendment process is outrageous. It needs to be amended. And there just needs to be more who support that mantra so that that proposed constitutional amendment can actually make it to the ballot.
I mean, I elected this person to know what they're voting for.
Right.
To do it silently.
Right. I don't think she meant silently. She meant more. Mm-hmm. Right. I don't think. Yeah. There is peer pressure, but I think we need to have, I do think people need to be accountable at that time. So I do think that you need to have open hearings. I think closed hearings, right, this is my own personal opinion, you know, but, right, yeah, yeah.
That they place their vote silently, and we can certainly show roll call like we do now as to how legislators voted after the fact. There's a roll call in the paper,
Right.
almost every day as to how our legislators vote. You don't even need to read it because you know how they voted.
Sometimes you're surprised.
But the thing is that, well, here, I would say that's a pretty accurate statement. I've never been surprised yet. But, we could still, as voters, receive notification as to how our elected officials have voted. But during the actual process,
Right.
the only way you're going to get rid of peer pressure is to have them not have to publicly state at the time the vote goes down. As a voter, it doesn't matter to me if I hear when the vote is being made how my legislator voted, but I do want to know afterwards. But there's no, to me, there's no necessity in knowing how they voted at the time the vote was going down. I can't do anything about that anyway.
Yeah, I don't know any state legislature, state or federal legislature that operates that way.
I'm just
Yeah,
saying,
yeah,
there
mhm.
has to be something done. You commented. There have been more than one comment on the pressure.
Right.
You've made it, and people in the
Yeah.
audience have made it. So there has to be an answer to that. And I'm just saying, just look at January 6th to January 7th comment.
Yeah.
Answer, and I have a theory on that, but I'm not bringing that up.
Okay.
Are there any more questions? Well, thank you so much, Debbie, for a great discussion and a lot of information.
Thank you for having me.